Hello and welcome to Criminal Justice in a Nutshell. My name is Dr. John Fisher. Today's episode of Criminal Justice in a Nutshell is going to be the Brady laws. I'm recording live from, when you see it, it's not going to be live, but I'm recording from Cahoma RV Park in Cahoma, Texas. It's a oil field man camp right off of Interstate 20. There's Interstate 20 right there. It is a busy road, and you're going to hear the traffic going back and forth while I go through this episode. So, in our last episode, we were talking about ineffective assistance of counsel. This episode, we're going to be talking about the Brady rules, or what's commonly known as the Brady law. And it stems from the case of Brady versus Maryland. It is another portion of the super due process requirements for death penalty cases. Although the Brady rules extends to every criminal case. I think I'm finding that I do say a lot, so I do apologize. But anyway, let's get back to work. Brady addresses prosecutorial misconduct. It wasn't that the defense attorney was ineffective. It was that he didn't have all of the information that he needed to do his job. And he didn't have the information that he needed to do his job because the prosecutor, the state, didn't provide it, didn't inform it. Okay? So, the prosecutor, according to Brady, the prosecutor is required to disclose all evidence, both material evidence against the defendant and exculpatory evidence that could help prove that the defendant was innocent of the charges against them. Okay, the obligations of Brady is that anything exculpatory is called Brady material. Okay, and the intent of the state is irrelevant. It doesn't matter if the state intentionally suppressed this information and refused to disclose it to the defense or not. If it's found that it was in the possession of the prosecutor and it was not given to the defense, it is a Brady violation. Okay, so Brady versus Maryland is no longer just a case. It is a term. And it's used to describe the state's obligation to ensure that there is a fair and just trial. And we want to ensure that there's a fair and just trial to ensure that everybody is given the same equal treatment under the law, regardless of race, regardless of religion, regardless of ethnicity, regardless of their origin and their place of origin. Even the illegals, the undocumented immigrants that are crossing the border illegally, they are also entitled to these same Brady obligations. Many of you may have watched the Netflix series called Making a Murderer. It's about Stephen Avery and Brendan Darcy. Brendan Avery's attorneys argued that he was set up by the police. Brendan Dassey, I'm sorry, not Darcy, but Brendan Dassey. His attorneys are saying that his confession was coerced and that he didn't know exactly what was going on, what was being talked about. I've watched both seasons. I've kind of getting the feeling that Stephen Avery's attorneys, before the entrance of Kathleen Zellner, was trying to say that yes, Brendan Dassey did this, and he could do his own thing, but even though Dassey did this, there was nothing that to implicate that Stephen Avery was involved, and he was framed by the local law enforcement based upon a coerced confession from Brendan Dassey. Okay, so and then Kathleen Zellner is Avery's current appeals attorney, and all she deals with, in my understanding, all she ever deals with is Brady cases and Brady law. She reinvestigates the case. She looks for new evidence. She looks for evidence that the law enforcement should have had or should have shared. and then she brings it to court. She's a very successful attorney. She's also involved in the Melgar case here in Texas. But part of the Brady laws are two other cases. And this is another one of those names I can't pronounce. And that's NAPUE, N-A-P-U-E, or NAPE, I don't know how to pronounce it, versus Illinois. And this bars a prosecutor from knowingly presenting false testimony. A friend of mine got wrapped up in this a couple weeks ago. And she gave false testimony on the stand. She perjured herself on the stand, and I don't know what kind of trouble she's going to be into, but I know at the moment she's unemployed. And if the attorney knew that this individual was lying on the stand, she could also face disbarment. The attorney could. So, but NAPE versus Illinois, or NAPUE, requires that there's a duty on the part of the prosecution. Once they've learned that false information has been given, they have to correct that testimony, and especially when the state knows that it's to be false. Another part is Giglio versus Illinois, and it requires the state to disclose any deals that are received by jailhouse informants. Because one of the things that we have found is that a lot of these homicide cases are solved because of informants, confidential informants or some other informants, or that they're going to go testify, and they're going to go, yeah, Dr. Fisher told me that he was involved in this murder, and in exchange for my testimony here today, I'm going to be able to get paroled in 5 years. Or whatever happens, or whatever goes on with that. So Giglio versus Illinois requires that any deals be disclosed. Kyles versus Whitley. What happened here? What happened in this case is that the state knowingly suppressed contemporaneous statements made by 6 witnesses. That means these were statements by 6 witnesses that showed that Kyles was not involved in this crime, that showed his innocence. There were various records of statements made by the informant that implicated the informant in the crime. There was a list of license plates collected by the investigators that showed that Kyle's car was not there, and thus Kyle wasn't there to commit these crimes. And there's public records that were involved that actually implicated the state's informant. So what the evidence shows is that the state's informant is the actual murderer in this case and not Kyle's. The state turned around and said, well, we didn't know about these statements. They weren't provided to us. We can only prosecute based upon the information and the evidence that's given us by the police department. We cannot be held accountable under Brady. And what the court turned around and said, it created 2 new features of the Brady law. And that includes suppression of the police is the same as suppression by the prosecution. So now the prosecutor has got to conduct his own investigation as well. So he's going to get all of this information from the police department, and then he has to have his own investigator go through that information to make sure it's valid, to make sure that the bad guy's not going to get off on a technicality, or more importantly, that the bad guy's not even a bad guy, and that we're sending the wrong person to prison. So we need to make sure, and Brady helps ensure, and then Kyles reinforces that and says that even information that's suppressed by the police, it still is qualifications for appeal, and it violates the rights of super due process for the defendant. But there was another definition that came out of Kyles, and that was materiality. Okay, And the materiality is roughly equivalent to the prejudice that we talked about with Strickland and Witherspoon. Witherspoon's coming up, I'm sorry. Strickland v. Williams. Witherspoon will be in another episode. So you might see it as well. Okay, so, and that means, or that addresses that it's an equivalent to prejudice. And with all the suppression, if this is, and what it's saying or what it's asking is, does the suppressed evidence prejudice the jury? Okay, so if we've got some evidence that wasn't disclosed and it wasn't given to the defense, would that, even if that information was given, would it have changed the outcome of the case? Or would it have changed the outcome of the trial? Like in Kyle's, there's 6 witness statements that show that he wasn't even there and it wasn't him that committed this crime. His license plate number wasn't on the list of license plates that were taken from the parking lot. The informant had made some statements that contradicted what he was testifying to, and the state had information that implicated the informant. All of this prejudiced the jury. If the jury would have heard all of this, it's most likely that they would have found Kyle's not guilty. So that prejudiced the jury, and the case was overturned. Okay, so Strickler, not Strickland, but Strickler versus Green, the state clearly suppressed evidence and exculpatory evidence. They clearly, in this case of Strickler versus Green, but the court ruled that the suppression was not material. It didn't mean anything, and that the suppressed evidence wasn't enough to undermine the confidence in the verdict. And that's what the question that Strickler brings about. Is the information and the suppressed evidence enough to undermine the confidence in the verdict that was given by the jury? Okay. So, in conclusion, the Brady requires 3 things. First, that there is suppression, and this is on the part of the defense. The defense has to prove all of this. They have to prove that evidence was suppressed by the government. They have to prove that the evidence was exculpatory in nature, and that with this information, the defendant would have been found not guilty. And third, that this evidence was materially prejudicial, meaning that it had to, because of the lack of this information, because of the lack of this evidence, the jury was prejudiced against the defendant and found the defendant guilty. So, again, suppression, exculpatory, and material. These are the 3 aspects of the Brady Rule. Okay, this has been the Brady Rule, an episode in Criminal Justice in a Nutshell. My name is Dr. John Fisher. I hope you have a good day.